Good morning. I'm Jody Saffeir. It's Easter morning here in Maine, and it's nice to meet you all virtually um, the week before the class ends. And this is my second to last week in the MELP program. Um, so I'm excited to be wrapping up next week as well. So I'm looking at my final paper project being about the future of the Antiquities Act of 1906 and the implications of it on national monument protection, particularly some cases that are pending right now out west. Um, as a non-attorney, I'm choosing to approach my final project using the mock expert affidavit approach, not the mock legal brief. And so I'm going to be essentially formatting it as a research paper, concluding with my perspective on how the issue should be viewed by the courts. So from there, I'm building on a topic that I explored during the Model 1 assignment where we had to address a current natural resource issue. And I wrote about the 87,500 acre Katahdin Woods and Waters National Monument that was designated in Maine by President Obama right at the very end of his second term in office in 2016. And as we all know, a few short months later, President Trump issued a review of 27 different national monuments. All of them had either been created by President Obama or President Clinton. And while in the end, the Katahdin Woods and Waters National Monument was spared, some others, as we know, weren't so lucky, including Bears Ears and Grand Staircase Escalante National Monuments in Utah. As I was writing about Katahdin Woods and Waters, our classmate Kevin O'Riordan, my apologies if I'm mispronouncing your name, wrote about Bears Ears in response to that same assignment. Moving on to Module 3, where we were dealing with the preservationist ethic and restricted use lands, the writing assignment on current issues in protected federal land management had two options. I didn't choose the one that had to do with national monuments. Others, I'm sure, did. And so some of you did a deep dive into Bears Ears and Grand Staircase Escalante, and I didn't explore that at all. So I chose, I am interested in those and want to focus on them a little bit. But the issue really for me that I'm interested in exploring is what are the sideboards of the Antiquities Act? What does and doesn't the Act authorize the president to do? And what can be learned from past designations and or more importantly, from the rare instances in which a national monument was actually reduced in size or rescinded, and what implications do those actions have for the most recent and the most sweeping rollbacks ever exercised, those by the Trump administration during his first year in office. So my intention is to briefly review the history of the Act's creation, what its stated purpose is, and I think it's such a short act, and the language that can be argued about is there aren't a lot of words to it. So I think it often hinges on that the Act says what the president can do, but it doesn't say what the president can't do in terms of rescinding any national monuments. And it does have language talking about limiting the area of protection in all cases to be confined to the smallest area compatible with proper care and management of the objects to be protected. There are, however, cases that upheld large swaths of land, and so that seems to have some precedent to it to retain larger properties. So after just sort of reviewing the creation, the purpose, and some information on the national monuments that have been designated as a result of the Act, spend a little bit of time talking about the current controversy surrounding President Trump's decision to reduce the size of multiple national monuments, talk a little bit about Bears Ears and Grand Staircase Escalante, but really mostly focus on the legal perspectives on the scope of presidential authority under the Act. And I'll talk about that in a moment. But finally, I would end with a recommendation for reforms to the Act that could reduce, ideally, future controversies and ensure greater protections of existing monuments. Why it's important is that ultimately the importance of the properties under dispute, beyond, of course, their inherent value, the resources themselves contain, the resources that the national monuments under dispute contain, and the value that the communities place on them. Aside from that, is really what precedent their reduction in size will have on the future application of the Antiquities Act. So what will future presidents understand to be within and outside their authority to do with respect to already established monuments? What was really helpful to me in reading Kevin's post from Module 1, in addition to what his perspective was on it, and so I may actually reference him in my write-up, but Elizabeth Wiggins, another course mate, nice to meet you, put in her response, she noted two different sources that I think will be very helpful. One of them is a Congressional Research Service report on the Antiquities Act and its scope of authority for modifications of national monuments. Those CRS reports I find to be always good. This one's fairly current in 2016, so I will be relying on that. She also makes mention of or references a National Parks Conservation Association legal analysis of the president's authority to revoke national monuments, and that research concludes that the president has no power unilaterally to abolish or materially change a national monument designation under the Act. So I'll be digging into that as well. The Harvard Law Review blog in 2018 published a short but really dense piece by a law professor from the University of Colorado, Mark Squillace, where he talks about the looming battle over the Antiquities Act, and I think summarizes the issues and the possible interpretations that a court could take. And I think he concludes fairly optimistically that there is enough to argue in favor of the president not having the authority to rescind or modify previous acts. So we'll see about that. But one citing that I found really interesting is a nonprofit called the Property and Environment Research Center out of Bozeman, Montana. And it seems like an environmental nonprofit. I'm not familiar with it, but it wrote a piece just last year on looking at the history of reform, looking to history to reform the Antiquities Act. And his argument, I'm not sure I buy it, is that we would be fine if the president did not have the authority to establish national monuments. He focuses predominantly on the state of Wyoming, which is the only state through an amendment to the Antiquities Act. No longer can the president establish national monuments in the state of Wyoming. And that's the only state where that's the case. And he argues that, in fact, Wyoming's done pretty well since that point in protecting critical natural resources in the multi-million acre size. So I don't know. I don't think I agree with the argument, but he essentially says that the more that Congress is invested in seeing it as its authority to establish national lands of national significance as protected properties, the better things will be. So the more restriction, frankly, in the future on the president's authority to even establish them might actually be a good thing. So that is the scope. I'd be interested in any perspective that any of you have on resources about it, personal experience you have with particular national monuments beyond the ones that I've mentioned. And yeah, so I'm looking forward to digging in. And thank you so much for taking the time to watch this.